In the, I'm sorry, I want to go back again. Can you do it from there? To the, let's go back again, one more, that's it. These are part of the islands in the Spratly group. Scarborough Shoal is not part of the Spratlys. The Spratlys is to the south of Scarborough Shoal, and you can see very close, the closest, most of them are very close to Palawan, the Philippine island. The Spratlys are about 140 different features. The vast majority of them are underwater at all times. Another significant portion of them are underwater except at low tide, and they are called low tide elevations. There are relatively few of them that constitute true islands in the sense that they are above water at high tide. And a very, very tiny number of those even have vegetation on them. Now, the Spratlys have been the subject of contention among a number of states. All of the Spratlys are claimed by China. All are claimed by Vietnam. A number of them are claimed by the Philippines, and a few are claimed by Malaysia, and one or two by Brunei. In the third element of the Philippines' claim, that is, the focal point being first the 9-dash line, second focal point being Scarborough Shoal, and third, the Spratlys. And here, similar to the objective in regard to Scarborough Shoal, what the Philippines is attempting to establish is that these features do not generate more than a 12-mile entitlement. That is, they are, under the terms of the convention, rocks. They do not support human habitation or economic life of their own. And if, again, they have 12-mile entitlements because they are rocks, as opposed to 200-mile entitlements because they are islands capable of sustaining human life or human habitation or economic life, then their significance diminishes. And if they are all confined within 12-mile circles, then the reach of these islands or features does not extend very far. And again, this is a little more complicated than Scarborough Shoal. We're only dealing with one feature. But if these features generate no more than 12 miles, then there's a much larger area within 200 miles of the Philippines that is not covered by any of these circles and that would fall to the exclusive entitlement of the Philippines. Now, because there are so many features in this case, and it might be too complicated to put them all before the arbitral tribunal, the Philippines has identified 7 of them that are occupied by China and claimed by both the Philippines and China, and asked the tribunal to rule on the status of each of those 7 features. In fact, 4 of the 7 features are underwater at all times. They're not only not islands, they're not low tide elevations, they are shallow reefs. As such, they are considered under the convention and under international law to be part of the seabed, and they belong to whichever state has rights over the continental shelf. They cannot be seized and occupied by another state. You don't acquire title by occupation of an underwater feature. That's 4 of the features, including Mischief Reef, which I'll come to in a moment. And there are 3 features occupied by China in this area that look very similar to Scarborough Shoal. They're quite obviously rocks. So the Philippines has asked the tribunal, in the case of all 7 features occupied by China, to rule that, well, in the case of the 3 features occupied by China that look like Scarborough Shoal and stick out above the water at high tide, to rule that they have only 12-mile entitlements. And as to the 4 features that are permanently underwater, that these are not islands or rocks, and they generate no maritime entitlement. So the waters above them belong to whoever has the exclusive economic zone, and since they would be within 200 miles of the Philippines, they would appertain to the Philippines. Let me show you Mischief Reef, which is appropriately named. This is an underwater feature that's about 100 miles off, well, what you see is more than the underwater feature here. But underneath this structure, which has been built on top of it, there is a reef that is permanently underwater. This is about 100 miles off the coast of the Philippines and more than 600 miles from the mainland coast of China. In 1995, China seized Mischief Reef, even though, under the law, it is part of the continental shelf. As I said, it's not an island, it's part of the seabed, and well within the 200-mile continental shelf entitlement of the Philippines. This naturally caused a great deal of protest and led to discussions between China and the ASEAN states. Little by little, China began constructing on top of Mischief Reef. This is only one of several sites at Mischief Reef, but what they have done is they've built a barracks so that they could station military personnel there, a helipad so that they can resupply with helicopters, and gun emplacements so that they could defend Mischief Reef. Because of the great disparity in military power, the Philippines was able to do little more than protest and convene its neighbors and engage in discussions, but the result has been an expansion of the facility by China. This is one of the features that is included in the arbitration. Since this is an underwater feature and a state cannot transform an underwater feature into an island by building on top of it, this feature, the Philippines claims, is part of the Philippines continental shelf, and China is there illegally. After the arbitration was filed in January, China sent a rather large flotilla to another underwater feature about 30 miles to the east, also within 100 miles of Palawan, the Philippine island, called Second Thomas Shoal, or Ionjin Shoal. And although China has not yet constructed anything there, they have made public pronouncements that it is theirs, and they have told the Philippines that no Philippine fishermen may come, no Philippine naval vessels may come, essentially cordoned it off. Again, expanding, I think one of their generals referred to this in a magazine article as the cabbage strategy. But there is a risk of further expansion because there are many underwater shoals and reefs in this area, even closer to the Philippines, and of course a risk, given China's behavior to this point, occupying and fortifying Mischief Reef, now moving on to Second Thomas Shoal, that there's no indication that they will stop, or if so, where. Now, the Philippines had spent many years, actually negotiations go back to 1995, mainly bilateral, some multilateral. And at no point was any progress made in reaching any kind of a solution bilaterally. China simply held to the position that China has sovereignty and sovereign rights within the 9-dash line, and that includes sovereignty over all the insular features, reefs, shoals, cays, rocks within the 9-dash line, and there's no flexibility in that position in the negotiations. So the Philippines was faced with a very difficult situation that was getting worse. In April 2012, Chinese ships surrounded Scarborough Shoal and excluded Philippine fishing vessels. A tentative agreement was reached that both sides would remove their vessels. The Philippines did remove its vessels, China did not remove its, and China remains in de facto possession of Scarborough Shoal. And then in the spring of this year, China moved in on Second Thomas Shoal to the south and part of the Spratlys. So the Philippines was faced with a very serious situation. One, it could not exploit the resources in the areas to which it has entitlement under international law, including the UN Convention. Two, negotiations had gotten nowhere, and there was no indication of any softening in China's position. In fact, all indications were the opposite after the incidents at Scarborough Shoal in 2012 and Ayungin Shoal this year, or Second Thomas Shoal this year. Confronting China militarily was not a viable option. The Philippines doesn't have the kind of economic or commercial influence vis-a-vis China to cause a change in its behavior, and the options were limited. But the one option that appeared was the law, because in a court or before an arbitral tribunal, a small state that is weaker militarily, economically, commercially, has the opportunity, at least, to compete on equal terms with a much larger, more powerful state. And there's a growing number of precedents for this, particularly under the Law of the Sea Convention. Guyana and Suriname in their arbitration, Mauritius and the UK in their arbitration, Bangladesh and Myanmar, and Bangladesh and India, which I'm going over to The Hague to argue next week. In all of these cases, we have smaller, less powerful states unable to secure what they considered to be their rights under international law in negotiations with states that were more powerful or larger militarily and or economically, or both. And the smaller state resorted to arbitration under the Law of the Sea Convention. And that is what the Philippines did here. Now, just a couple of more words on this, and I will, this is Article 286 of the Convention, and it provides that, just to interpret it a little bit for you, where the parties have exchanged views on a dispute without resolving it, then either one can submit the dispute to third-party dispute resolution under any of the mechanisms provided for in the Convention. And in the next article, Article 287, it provides that they may take the dispute by agreement to the International Tribunal for the Law of the Sea in Hamburg, which is what Bangladesh and Myanmar did, or to the International Court of Justice, or to a tribunal, an arbitral tribunal that they would constitute by mutual agreement. But failing agreement to go to any of these forums, the fallback, the default mechanism is paragraph 5 at the bottom. If the parties to a dispute have not accepted the same procedure for the settlement of the dispute, it may be submitted only to arbitration in accordance with Annex 7, unless the parties agree otherwise. So what this means is if one party initiates a dispute under the convention, the other party does not want to agree to any particular forum, that does not frustrate or stop the arbitration. The claimant state has the right to take it to arbitration under the rules specified in one of the annexes to the convention, and the respondent state, the other state, is obligated to participate, is obligated by that choice, and is obligated by the decision of the arbitral tribunal, I should say. Let me see. I don't think there's anything else here that I want to go into right now. But so under Annex 7, that is how the arbitration was initiated under those procedures. The way it works is the claimant state appoints an arbitrator. Bangladesh appointed a very distinguished international jurist who's a judge on the International Tribunal for the Law of the Sea from Germany, Judge Rüdiger Wolfram. Then the other state has the right to appoint an arbitrator. And then the states try to agree on 3 neutral arbitrators, including the president. If they're unable to agree, the convention provides that those arbitrators will be appointed by the president of ITLOS, the president of the International Tribunal for the Law of the Sea in Hamburg. China took the position from the very beginning that they would not participate in the arbitration, so they did not appoint an arbitrator. And one was appointed in lieu of their choice by the president of the International Tribunal for the Law of the Sea. And then they refused to negotiate over the other 3 arbitrators, who likewise were appointed by the president of the International Tribunal for the Law of the Sea. We have an arbitral tribunal, and I've been before many, that is clearly one of the most esteemed, expert, respected group of Law of the Sea experts that could possibly have been assembled. It's provided over by Judge Thomas Mensah of Ghana, who was a president of the International Tribunal for the Law of the Sea. It has Judge Wolfram, who I mentioned. It has Judge Jean-Pierre Cotte from France, another esteemed expert and judge on the ITLOS tribunal. The Polish judge, Judge Polak, from the ITLOS tribunal, is also a member appointed by the president of the ITLOS tribunal. And the 5th member is a very, very distinguished Dutch expert, Alfred Soens, who's the director of the Netherlands Institute for the Law of the Sea. So it's a very serious, very prominent, very expert tribunal. China still has refused to participate, but the Annex 7 provides in Article 9 that in the event one of the parties refuses to participate, that does not frustrate or stop the arbitration. It proceeds. The members of the tribunal have a particular burden of establishing to their own satisfaction that the claims of the claimant state are supported by facts and law. They cannot simply enter a default judgment, as might happen in a national court in the United States. So it's still a rigorous procedure. Article 11 provides that the award, the judgment of the arbitral tribunal is final, it's not appealable, and it is binding. It's obligatory on all parties as a matter of international law. To this point, the tribunal has met its established rules of procedure, and it has set a schedule which requires the Philippines to submit its written pleading, what we call its memorial, its arguments on the facts and the law and supporting documentation by the 30th of March 2014. So the Philippine legal team is hard at work on that as we speak. After that, the tribunal has reserved judgment as to what the next steps will be. It will give every opportunity for China to change its mind and participate. It'll keep the door open for as long as possible. But ultimately, it will proceed to consider the Philippines' claims, its evidence, and its legal arguments, and ultimately render a judgment. And we expect that judgment to be rendered sometime in 2015, probably by the middle of 2015. It will be binding on the Philippines, and it will be binding on China. Whether China adheres to it is an entirely different question, maybe one that some of you have comments about. But right now, our task is to present the claims to the tribunal and to obtain the relief that the Philippines has requested. And with that, I will turn it back over to Ernie, who I'm sure will invite your questions.
I will. Thank you, Paul. That was fantastic. And I want to start with a question, but just to get everybody ready, if you have questions, please identify yourself and your affiliation and ask the question. I'd like to start with a question of how would it be enforced? How would the judgment be enforced if China disagrees with the judgment, and if it were awarded to the Philippines?
Well, it's of course a very good question, and it's not something that is how can I say, unanticipated by the Philippines. There's no posse, there's no police force, there's no sheriff who might be ordered by a local judge to go and make the defendant comply with the order. It is largely a question of whether a state that is subject to a judicial order or an arbitral award chooses to comply or not. But having said that, I should point out, number one, that in 95% or more of cases decided by the International Court of Justice, the International Tribunal for the Law of the Sea, or arbitral tribunals that have been convened for interstate disputes, in at least 95% of those cases, the states that are, quote unquote, the losing party comply. We see this also in investor-state arbitrations, although the compliance rate may be a little bit lower, but still in the vast majority of investor-state arbitrations under bilateral or multilateral investment treaties, which may involve judgments of hundreds of millions of dollars. In the vast majority of these cases, the states comply. And the question is, if there's nobody who can force, if there's no army, there's no police, who can force a state to comply, why did they do it in the vast majority of cases? And I think that part of it, part of the explanation is that there is a heavy price to pay for a state that defies an international court order or a judgment of an arbitral tribunal that is seen, that is recognized in the international community as legitimate, as fair, as correct, as appropriate. There's a price to be paid for branding yourself as an international outlaw, as a state that doesn't respect, that doesn't comply with international law. There is something to be said for soft power and for the ability, the component of soft power that is composed of a state's ability to defend its actions as legal in the international system. as explaining and defending itself as respectful of international norms. It becomes an important part of a state's ability to influence other states. Now, it is important, therefore, not only for the Philippines to obtain a judgment in its favor, but for that judgment to be seen as impeccable